Kevin helped us talk through the ideas of tribal sovereignty and um, the idea that state authority to interfere in tribal affairs is limited by federal law. What I'm going to focus on is federal government's responsibility to Native people, and also the question of federal power to fulfill that responsibility and to make federal Indian law and policy. So, in the course of this session that I'm going to be speaking in now, you will learn how to define the trust responsibility and explain how it matters in reporting, to understand how the Trump administration and the Supreme Court have taken certain actions and made certain decisions that have interfered with Congress's power to determine policy and Congress's self-determination policy. So where we heard, for instance, from Kevin about the many Supreme Court decisions in which tribal interests have prevailed, I'll be telling more about the other side of the story. And finally, we will talk about ways to think about concrete examples, including, for instance, tribal consultation in the area of oil, gas, and mineral extraction, which may be an issue that you're familiar with in the context of Standing Rock, for example. So let me start with the first takeaway from my remarks right now, and that is focusing on the government-to-government relationship between the federal government and tribal nations and the trust responsibility. The trust responsibility is the responsibility that the federal government owes to Native people. The details of that I will talk through in just a moment, but I want to highlight first why thinking about the trust responsibility should lead us to recognize that understanding the unique history of Native people and tribal nations is quite important. The federal responsibility owed to tribes has a deep history. It goes back to the treaty-making period. Many treaties between tribal nations and the federal government pledged the federal government to a duty of protection. It's often phrased in terms like that, a duty to protect tribal territories, to support tribal nations in various ways, and that responsibility, which stems from the government-to-government relationship, so the relationship that tribal nations as sovereigns have with the federal government as a sovereign, has persisted to this day. One piece of evidence that it's persisted to this day is the judicial recognition of this unique relationship between the federal government and tribes. So in the Holland versus Brackeen case, for example, Justice Barrett wrote an opinion reaffirming and recognizing once again that unique relationship. And so when we think about what makes this relationship unique, one point of comparison is the relationship between the federal government and the states. And so one lesson here is in reporting on Indian country issues and tribal governments and their relationships to the federal government, we need to start from the starting point of recognizing that this is a unique relationship. There's unique legal rules, there's unique histories, and we can't simply treat the relationship here between the tribal governments and the federal government the way we might treat the relationship between state governments and tribal governments. There are many contemporary examples of the government-to-government relationship. We can see it play out in legislation, for instance. We can see it play out in the efforts that tribal nations have made, often quite successfully, to lobby Congress for changes such as the changes to federal law and policy that Kevin described earlier, the changes related to Congress coming in and fixing a problem that the Supreme Court helped create with its jurisdictional rulings by enacting legislation that provided for federal recognition of tribal sovereignty and authority in the criminal jurisdiction space. The federal executive also plays an important role in the carrying out of this government-to-government relationship and the fulfilling of the trust responsibility. One example of that that's really salient for one of the concrete case studies that I'll talk about later is the executive orders and policies related to consultation between tribal governments and the federal government about regulatory policies that have implications for tribal peoples. This slide has pulled out some quotations from what was a landmark executive order issued by the White House during the Clinton administration. It's Executive Order 13175. The executive order makes it policy for the executive branch to consult with tribal nations when the executive branch and its agencies and departments are contemplating creating regulatory policies that have implications for tribal peoples. And in this order, President Clinton recognized the unique legal relationship, that government-to-government relationship that, as I said earlier, distinguishes the relationship between tribes and the federal government, say, from the relationship between states and the federal government. And this executive order also recognizes as a foundational principle tribal sovereignty and tribal rights to self-government. I highlight both Congress's role and the role of executive policymaking at the outset here, because one of the big takeaways from my remarks is for us to think about legal issues involving federal responsibility and federal power by looking beyond the courts. A lot of the tribal advocacy, a lot of tribal efforts to hold the federal government to its trust responsibility and duty of protection have taken place in the halls of Congress or in interactions with the executive branch. So Congress has implemented the trust responsibility in many federal statutes, some of which I'll highlight later. The executive branch, when implementing those federal statutes, has recognized and implemented the trust responsibility. And as I'll talk about later, there are some opportunities for court enforcement, but a lot of the work that the trust responsibility does is through advocacy outside the courts as well. So I haven't sort of specified what the trust responsibility requires under contemporary law, and I now want to do that. And I want to begin by saying that some of the legal concepts here may be familiar to you, especially to those of you that have reported on, for example, businesses or nonprofits. You're familiar with the idea of fiduciary responsibilities in law, the idea that corporate directors, for example, have fiduciary responsibilities to shareholders. Nonprofits directors have fiduciary responsibilities related to the purposes of the nonprofit. And so while the trust responsibility does involve unique legal rules and unique aspects, some of which I'll spell out in just a moment, I also want to highlight that some of the basic legal ideas may well be familiar to you in the ideas that there are trustees, for example, there are other fiduciaries that have certain duties to the beneficiaries of a trust. So one aspect of the trust responsibility to highlight, one foundational aspect, which comes under the label often of the duty of loyalty, is that the federal government has a responsibility to support tribal uses of tribal resources and not to take tribal resources for someone else's use. This seems very basic, very obvious. It's also a responsibility that the federal government has broken many times throughout the history of the United States. This is a responsibility that has been judicially enforced in some instances. And it's a responsibility that remains quite relevant to legal issues today. The second basic aspect of the trust responsibility is a requirement that the federal government be competent and careful in how it goes about supporting tribal peoples. That this is often called the duty of care. And one feature of this responsibility that's important to highlight when we think about the ways in which federal Indian law is unique and the relationship between the federal government and tribal governments is unique is that the trust responsibility includes an obligation to support tribal self-government and tribal self-determination, to support tribal sovereignty in concrete ways. And I will highlight some of those ways as I continue to go through my remarks. So if that's the federal responsibility, it does raise this question, who within the federal government has power to fulfill that responsibility? The obligation is on all of the federal government, but how does the federal government itself divvy up authority with respect to the making of federal Indian law and policy and the fulfilling of the trust responsibility? And the basic message I want to get across here is that under our constitutional system, Congress is in the driver's seat, and that matters both for how we think about the law and how we think about reporting about the law in this area. So in our constitutional system, we've got this basic idea of the separation of powers. We've got an executive power, a legislative power, and a judicial power, and that these powers are separated amongst the three branches of government. When it comes to the federal government's powers related to Indian affairs, they do stem from multiple parts of the Constitution, its text, and our constitutional history. But one part to highlight here that helps focus us on why Congress is supposed to be in the driver's seat is the Indian Commerce Clause, which says that the Congress shall have power to regulate commerce with foreign nations and among several states and with the Indian tribes. One thing to notice about this text is it lists three types of sovereigns, all there together in a list: foreign nations, states, and Indian tribes. And another thing to highlight about this text is that it is focused on Congress's power and Congress being in the driver's seat with respect to the regulation of commerce with the Indian tribes. And these words are being written down in the Constitution at a time when commerce was understood to mean something more than just economic activity, more than just buying and selling. It meant interacting with. Okay, it was often used synonymously with the word intercourse, which at the time was, viewed a word that would refer to relations among different peoples. That was one of its usages. As Kevin said, we often refer to Congress's authority in this area as plenary power. And as one of the questions we got earlier raised, the question about Kagama, and do we think the court is going to revisit Kagama and revisit what it said about plenary power? This question is, I think, quite important and quite timely, because when plenary power is first recognized in the Kagama case in the late 19th century, the Supreme Court doesn't try to tie it into the Constitution and doesn't seem to suggest that it's limited by the Constitution. And this gives rise to the idea that the plenary power is the power to do whatever the federal government wants as a legal matter. More recent cases have said, however, that that is not the case. That, as the court said in Holland versus Brackeen, Congress's Indian affairs power is not absolute. Plenary power does not mean that Congress can do whatever it wants to Native people. That the Congress's authority is grounded in the Constitution and limited by it. You're probably familiar with the Holland versus Brackeen case. It was a case testing the constitutionality of the Indian Child Welfare Act. There were many different kinds of constitutional challenges to the act, the Supreme Court decided some, but not all of those challenges on the merits. It dismissed some of those challenges based upon jurisdictional issues, saying we don't have the power to reach this particular question at this time in this case posture. So the court, for example, did reach a what we call a structural constitutional challenge. For example, it reached this argument that the Indian Child Welfare Act violated a constitutional rule against the federal government just issuing bare commands to the states to make policy. The court said ICWA did not violate that, but the court did not reach, for instance, the merits of an equal protection challenge to ICWA that relied upon an attempt to challenge existing law and to say that ICWA's classification of Indian status violated the Equal Protection Clause, or the Equal Protection component of the Due Process Clause of the Fifth Amendment. And in Q&A, we may well come back to that issue because it's related to it's both timely, it's related to many of the topics that Kevin raised around tribal government authority with respect to non-Indian people. So Congress's plenary power is not absolute. How is Congress wielding that power it has when it's in the driver's seat to make federal Indian law and policy? Well, here we want to understand when we're thinking about reporting on Congress and federal policy today that we're in an era of the self-determination policy where across many different statutes, and this is a history stretching back to actually the Nixon presidency and President Nixon's message to Congress supporting tribal self-determination, that Congress's general policy is to support tribal government and tribal economic development. And as I said earlier, I was going to highlight some examples of this that are important to be aware of when you're reporting on current issues in Indian country. One of these is the practice of self-determination contracting, which implements federal statutory law. The federal government enters into agreements with tribal governments to support tribal governments providing, for instance, government services to tribal people. In these agreements, the federal government pledges to provide financial support, and the tribal governments pledge to use that financial support to provide services. Kevin has already highlighted this for us a bit. It's a very important and core piece of the government-to-government relationship and an important way in which Congress has tried to implement its commitment to tribal self-determination. Tribal consultation and co-stewardship and co-management are other examples as well. I'm going to talk more about tribal consultation in just a moment. And I know there's been a lot of interest in the topic of tribal governments and federal governments coming together to cooperatively steward, for instance, natural resources, places and spaces, waters, and perhaps we can come back to that in the Q&A as well, if there is interest in doing so. So Congress has this commitment to a self-determination policy. There are ways in which the other branches have supported that, and there are ways in which that they have interfered with that policy. So let's take a look at the Supreme Court first. We do see in cases like Dinesby, which Kevin talked about earlier, strong statements of support for tribal self-determination from the Supreme Court. So the picture here of the jurisprudence is at least a mixed picture. In Dinesby, for example, the Supreme Court said, when you understand the history of the government-to-government relationship and the history of tribal sovereignty, you recognize that tribes have pre-constitutional sovereignty, that this has been affirmed many times by the federal government and by federal law, and that one incident of tribal sovereignty is the power that Kevin described earlier to make and enforce laws, including make and enforce criminal laws. At the same time, It is also the case that the Supreme Court has rendered decisions in the modern era that have interfered with the modern Congress's tribal self-determination policy. In Castro Huerta, which Kevin talked through, the holding there was one that allowed the state of Oklahoma to exercise criminal jurisdiction over a non-Indian person. But there's also lots of statements in the Castro Huerta case that are examples of the Supreme Court acting in ways that are inconsistent with Congress's commitment to tribal self-determination. So this quotation, the general rule is that Indian tribes lack criminal jurisdiction to prosecute crimes committed by non-Indians, such as Castro Huerta, even when those crimes are against Indians in Indian country, is an example of this. This is a restatement of the Oliphant rule that Kevin referred to earlier, a rule that's been partially rolled back by Congress in an exercise of its power to be in the driver's seat and to recognize tribal sovereignty. But this rule has had really destructive effects for Native people, for safety in Indian country, and for tribal governments, as Kevin talked about earlier. What about the presidency and the president? Kevin has highlighted for you one example, or multiple examples from both the first and second Trump administrations of actions that aim to support tribes. It's also true that the president, not just the current president, but other presidents as well, but including the current president, have taken actions that are inconsistent with the policy of supporting tribal self-determination and the trust responsibility. These include unilateral actions such as clawing back and trying to take control of federal spending and to not spend money that's supposed to be spent for, say, benefits programs for Native people. It also has involved the revocation of executive policies that were supporting tribal self-determination, and I'll give some concrete examples of that right now as I conclude my remarks. So I want to focus on two different concrete examples to help us think about lessons for reporting to be drawn from my remarks today. The first is, let's talk about tribal consultation, which I've already said a bit about. But now let me try to define it a bit more specifically. So what is tribal consultation? Well, here is one important definition. This one comes from the National Congress of American Indians in a 2011 document. Tribal consultation is a requirement, quote, to meaningfully consult with tribal governments on a government-to-government basis regarding any matter of tribal implication in order to allow any affected tribal government to express its views and assert its rights in advance of the decision, okay? So notice this is focused on that unique government-to-government relationship between the federal government and tribal governments. It's focused on the idea that the consultation has to be truly between the governments, between representative of both governments, and that it has to be meaningful and timely. That is quite important to remember when we think about reporting on the government-to-government relationship, including in concrete examples that I'll get to in just a moment. So what we have seen over time, and especially recently, for instance, during the Biden administration, but not only the Biden administration, is more and more executive agencies and departments adopting policies for their own approaches to tribal consultation that take the responsibility to consult with tribes prior to making policy more seriously. So just one example is from the U.S. Department of Transportation, which 2023, in its tribal consultation policy affirmed that the federal government has an affirmative responsibility to proactively seek out consultation between federal and tribal officials, and to do so for policies that have tribal implications or affect tribal interests. Tribal consultation is important across many areas of policy. I'm just going to highlight one that's come up multiple times in the last decade or so when it comes to reporting on Indian country. Standing Rock is one, but not the only example of this. So the concrete example would be reporting on resource extraction and infrastructure development in Indian country. There are multiple federal laws requiring consultation, as I said. For some time, two such laws that have been important in this area. So you think, construction of pipelines, for instance, are the National Environmental Policy Act and the National Historic Preservation Act, NEPA, and NHPA, Section 106. There are also executive orders and policies that bear upon consultation in this area. I've spent a lot of time emphasizing Executive Order 13175 because it is the touchstone for a lot of executive agency policies in this area. And as I've said, and as I showed with the Department of Transportation policy, many agencies have their own policies on tribal consultation. So these statutes and policies have required the federal government in a timely and meaningful way to consult with tribes when, for instance, they're considering a permitting decision related to resource extraction or infrastructure development, for instance, related to a pipeline that would affect tribal people. We are in a time where we are seeing some changes to the policies related to consultation in this area. Project 2025 included among its many goals permitting reform, which I take to mean an attempt to speed up permitting process and to potentially reduce procedural requirements or eliminate procedural requirements related to permitting. Could this impact tribal consultation requirements? Possibly. We've already seen the Trump administration eliminate the Council on Environmental Quality's regulations under NEPA, which were a very important source of a legal requirement related to tribal consultation in this area. And Section 106, which is a federal statute that requires consultation when federal undertakings may affect historic properties, and that includes tribal cultural properties. Section 106 is very much still on the books, but there have been recent hearings. There has been a recent hearing in the Senate to consider whether there should be amendments made to Section 106 that might affect its requirement of tribal consultation. I'll conclude by just very briefly highlighting that spending is another area of a great deal of development, including recently. Federal spending is supposed to be an Article I power of Congress. It is an Article I power of Congress. The way that Congress approaches spending is the House and the Senate have their own rules of procedure that have said that spending is basically a two-step process. The Constitution itself doesn't spell out this two-step process. This is House and Senate rules for proceeding. But first, you need an authorization for, say, a spending program, like a program that would require spending. And then second, you need an appropriation of the monies for it. Recent federal spending issues of concern to reporters working on Indian country issues include actions related to SNAP, to healthcare money, to education. The Trump administration's unilateral actions with respect to the spending of money not only raise just basic constitutional questions about can the president do this generally, but also raise questions around the specific obligations that the federal government owes to tribal people under the trust responsibility. So the takeaways from this are, if you're thinking, how would I report on federal responsibility and federal power related to Indian affairs in Indian country? One takeaway is ask the separation of powers question. Does the government branch doing this have the power to do it? Isn't Congress supposed to be in the driver's seat in the area of Indian affairs? And ask the trust responsibility questions. Does this action violate the trust responsibility? Can the tribes go to court to enforce the trust responsibility? The answer is sometimes yes, but the Supreme Court has narrowed the circumstances under which Native people can go to court to enforce the trust responsibility. It did so most recently in the Arizona versus Navajo Nation case, which feels like a very textualist case that says the federal government owes judicially enforceable responsibilities to a tribe if we can find a specific enough textual hook for judicial enforcement. So to wrap up, the takeaways are it's useful to ask, does this branch of government have the power to do this? Does this violate the federal responsibility to tribal people? Unilateral actions that take tribal resources or otherwise harm tribal peoples may violate the trust responsibility. There may or may not be court enforcement for that violation. Courts are only one tool, and they're not always the most effective, although they sometimes are effective in enforcing the federal responsibility to tribes and holding the federal government to the limits on its powers related to Indian affairs. So with that, I will stop my sharing. I appreciate your patience with me and the tech issues. I clearly have some more practice to do, and so my apologies for that.
It's all good, Professor Davis. Okay, you have two questions in the queue. If you want to, I can read them or you can read them,
Please
whichever
go
you
ahead.
prefer. Okay.
Yeah.
So the first is actually from Jay Jones as again says, what about energy via the AI data centers or Bitcoin mining? Also, tech companies are buying nuclear plants. Is there a resurgence in nuclear energy activities on tribal lands? And then the second
Yeah.
question deals with federal trust responsibilities. So we can get
Okay.
to that next.
Okay, great. So I would also invite Kevin or Merri to weigh in as well. One aspect of the question is to what extent is there a resurgence of a turn towards nuclear power on tribal lands? And nuclear power has and remains an issue. I don't know that there is a marked resurgence. I have seen advocacy for greater use of nuclear power, and I've also seen advocacy around the potential risks of the use of nuclear power. Um, and if Kevin or Merri want to speak to that as well, I'm happy to invite them to. I do want to say though beforehand, I think that the push towards greater and greater energy demands related to AI is a really important issue to track, and it could very well implicate Indian country issues. It could very well implicate the sort of permitting issues, the sort of environmental review issues that I was highlighting in the context, say, of pipelines, depending on exactly where these, additional facilities are going to be constructed, how the energy is going to be routed. It's going to be routed across federal public lands, or there are going to be attempts to route it very close to tribal lands and communities. So it can implicate all the federal issues that I highlighted, and it's one of many issues in the area of energy. I also think of water here as well, that are putting real pressure on the doctrines that we've been sharing with you today. And so I definitely think it's one to keep an eye open on.
Let me just add, nuclear energy production is very highly regulated, as is, how what we do with spent fuel and that sort of thing too, and by the federal government, and that's highly federalized, and so that's always going to be true. Some of you may recall that there were efforts many years ago to site a disposal site on tribal lands, and that never came to fruition because of a lot of opposition. But we often see, uh, you know, poorer communities and Native communities as potential locations for those kinds of things, and so I could see that coming up again. I doubt there will be a nuclear facility itself located on federal land, but you never know. But it would come with all the federal, all the existing federal regulatory requirements, and so so stay tuned, but be especially on the lookout for issues like Seth raised, and maybe the location of disposal sites for nuclear, used nuclear fuel rods or something like that.
Okay. The second question is from Nell and Kevin O'Brien. Can you please address how federal trust responsibility to tribes affects off-reservation, treaty-based natural resources on public lands, i.e., fishing and hunting rights?
Sure. So, and the focus is on federal public lands. So,
Correct.
yeah. So there's a lot to be said here. I'll try to highlight a few key considerations. So, the trust responsibility does extend to that duty of protection does extend to these fishing resources, for instance, that are of importance to tribes. Okay. And in any particular case, we would, as from a lawyer's perspective, we'd be starting with questions like, does this, if we're interpreting a treaty, what treaty are we looking at? What does it say about, for instance, off-reservation hunting and fishing rights? But I think the baseline is that the responsibility does extend. I think that that can mean many different things. So if we're focused on federal public lands, we'd have to ask whether a federal agency is, for instance, taking, fulfilling, and it's making decisions about those federal public lands, whether it is fulfilling the trust responsibility. We'd have to ask if it's not, is there a way to get judicial enforcement of that responsibility? And there we can potentially run into the restrictions that I referred to when it comes to Arizona versus Navajo Nation. So what's the upshot of that? One key aspect of this is we'd need to look at the specific treaties and also the specific statutes and regulations related to the lands that we're dealing with, the agency that we're dealing with, to see what do they say about the duties, to see whether there's a basis for court enforcement, but we also need to think as well about the ways in which the trust responsibility can be mobilized by tribal advocates when they are arguing to Congress, when they are arguing to, when they are consulting with a federal agency, as the agencies are required to do, as I spelled out. There's also off-reservation hunting and fishing issues that arise with respect to the relationship between tribal peoples and states. So, and there again, the trust responsibility can, I think, be an important, especially in the backdrop. So, if states, if we are dealing with off-reservation hunting and fishing rights on lands that states have authority with respect to, the tribal rights persist, notwithstanding state authority, and the federal government has a responsibility to come in and fulfill that duty of protection if the state is threatening off-reservation hunting and fishing rights. And we've seen that be judicially enforced, for instance, in the Pacific Northwest, in the Bolt decision and subsequent decisions is a famous example of that. So that's just in addition to thinking about the specific frame for the question. That's also an important piece of the picture as well.
I know we're at time and we're about to go to break, but one of the questions that came in deals specifically with the issue regarding the trust responsibility at this time where we're dealing with agencies that are incredibly understaffed or under-resourced given what's happening at the federal government level with either the effects of Doge
Yes.
or the shutdown. Um, I was wondering if you want to go ahead and give your opinion on is lacking staff or not taking care of, the regular everyday responsibilities that the agencies are responsible for a violation of the trust responsibility.
So I think this is a really important question and one that we need to think about really carefully. I mean, one of the takeaways that I tried to get across in my remarks is courts are not the full story here. A lot of the work of ensuring that the trust responsibility is fulfilled involves tribal relations with agencies and departments of the federal executive branch. And that means, if we're thinking about reporting on this area, we need to really try to understand the structure of those agencies, the way they've structured themselves in regard to making policy and making decisions that affect tribal peoples, their procedures and processes, and just simple, things like staffing and the amount of resources devoted to fulfilling the trust responsibility and the government to government relationship, and that all of those are political aspects of the trust responsibility, certainly. Okay. Aspects where if the federal government is, failing to fulfill its obligations because of it's not devoted sufficient resources. I mean, that is a basis for political advocacy by tribes, citing the trust responsibility. Absolutely. And one very concrete example of this to follow that I think is quite important in the tribal consultation space is many agencies in the prior administration committed to having tribal liaison officers or the equivalent to be a point person for government to government relations, to at least be the person who could help open the door to government relations at the agency, to monitor the agency's fulfilling of its trust responsibilities or its consultation obligations. And so we want to track things like are those offices still filled, right? And if they're no longer filled, that creates the kind of concern you're raising. I do want to be precise, though, on one point. Um, I was just talking about, sort of political advocacy and violations of the trust responsibility as a political obligation. Um, Legal enforcement of the trust responsibility, especially after Arizona versus Navajo Nation, is going to be narrower than some of what I just said. And it's going to be narrower because of the court saying we're going to limit judicial enforcement to these instances where the duty to be enforced has to have this strong enough textual basis. And so that creates, while that doesn't eliminate all judicial enforcement, it does create significant limits to going to court to enforce trust obligations. So to try to be very concrete to conclude, um, changes to staffing at an agency or department might put the federal government in a position where it's not actually fulfilling in a competent way its trust obligations to tribal peoples. That could be true. It could be a basis for political advocacy, but it might not, at least not necessarily, be a basis for getting into court for a successful case that ends, for instance, in an injunction.
Okay. I don't know if Professor Washburn wants to say anything about that as well. Um, Otherwise, we'll go ahead and break.
I'll just say this on the probate question specifically.
Oh,
Um, Doug Burgum, the Secretary of the Interior, has said this is an issue. I mean, this is an area where Republicans are sometimes more focused than Democrats, property rights, right? And probate has to do with property rights, basically. And so, the current administration says they want to do something about these probate delays. And you can't lay all the entire BIA off and then expect the BIA to work faster, right? That's exactly what Seth was just saying, basically, in more academic words. But I think that it's on their radar screen, and so I think it's they've put their arms around that issue, and so we will be able to see whether they can improve that particular issue. And that's something they've taken on to try to fix, and so they can be held accountable for whether they fix it or not, since they've identified it as something that they think needs to be fixed, and it does need to be fixed. It's the challenge is in the BIA is somebody might have an estate that's worth $100, and it might take thousands and thousands of dollars to probate that $100 estate, but it still has to be probated. And there's kind of a lot of issues like that kind of objectively don't make a lot of sense, but they end up creating a lot of problems, tying the government in knots. And it means that the government's not fast at getting to the much larger estates that are probably more meaningful. So it's a challenge. We'll see how this administration does, given its shrinking staffing.